Hi everyone, my name is Dylan Grant and welcome to part 8 of my presentation on Naimark Law Firm, the criminal activities of Naimark Law Firm. Ryan Naimark, Courtney Madison, they both joined forces with Hicks Morley Law and Nicolini Law to falsely represent my cases. Please feel free to pause and read. I'm trying to go fast as possible. I hope I'm not boring you. I hope you're finding my presentation interesting, okay? It could happen to any one of you. All right, I'm sharing. And I need compensation too, all right? It was now Naimark Law's turn to complete its deception, Ryan Naimark and Courtney Madison, between 2019 and 2022. 2019 and 2022, okay? September 2020 continued. So many things went on, I tell you. I stir up a nest, something. Wow. Cancellation of the examination for discovery September 29, 2020 without my consent. The case wasn't mine. It belongs to Naimark Law, so they can do anything. And they can do anything and go against their contract because they know the system would back them. They knew that. And the thing about it only makes sense I report them because nothing would have been done. I reported the doctors to the colleges and nothing was done. So it was pointless for me to do otherwise, right? But they breached their contract, okay? And I will prove it to you. Courtney Madison Naimark Law canceled the examination for discovery on September 29, 2020. Her final reason, D, number 5, for cancelling was that it should have been a mediation. She just realize that 1 year and 2 months later? Courtney Madison stated via email and phone call that she would contact me in the month of October 2020 with a date within the month for a mediation. Waited October and November 2020, but no emails or calls were received from Courtney Madison or from the office of Naimark Law Firm. See emails on next slides. Waited for 2 months and still did not have the meeting I had requested, which was scheduled for September 25th, 2020 at 2 p.m. I still needed to speak with my lawyer, right? Was she scared to speak with me? Because I may cornered her without the defense present? Wow. I cannot get a one-on-one with my lawyer. It was now over a year, And now the discovery was cancelled again without my consent, okay? By the way, I didn't see, I think it's in this. Let me go ahead. I will explain as I go along. Thank you. Would you trust this lawyer, Naimark Law? As soon as Naimark Law realized that I was asking the appropriate questions due to their deception, they did not want to deal with me anymore. I was forced to attend a mediation with no discussion of an amount being sued. I was forced to attend a mediation with us not having the same information on why I am suing these entities, Wow. Okay, on September 28th, 2020, call received in the morning, right? As I did indicate. And she did tell me out of her mouth, okay, that mediation. She misguided me. That's exactly what she said. All right. And this is what was this is I have proof of this elsewhere. I think I did show you in another presentation explanation. Explain stages of lawsuit. Nothing was explained to me, but as you can see here, feel free to review. Okay, I think it came from this information here, but anyway, it says here after the pleading is the pleading stage, and you have the discovery stage, then motions and all that. Okay, feel free to pause and read, because I did say to her, because that's what she said. Whatever I heard, I'm putting it back in writing because I am making sure, you understand? I heard what she said. You had indicated that a mediation should have been offered instead of an examination for discovery because mediation is usually the first option. That's what she said. Okay? And I'm not making up stories. Okay. So what had happened here, Courtney said, I brought this forward for a reason, right? 2:19 p.m. Courtney Madison emailed me, and she said, I confirm I have recommended to you that we engage in settlement discussion, and adjourn your discovery by 1 month. Settlement discussion means mediation. Settlement discussion is not examination for discovery. She also explained that to me, and I also read that. You understand? So I'm not making up stories, okay? And then 3:19. This was 2:19. Mark you. She said 1 month. 1 month is not a discovery. Not a discovery. She wants a settlement to do whatever, and then if anything can adjourn the discovery for 1 month. They're gonna try a settlement, mediation, that is. So at 3:19, she said, I highly recommend that you accept my offer to put over discovery 1 month and focus on negotiating a settlement in the interim. Mediation. You understand what I'm trying to say? How can a mediation come before a discovery? You understand me? So when she said, if I didn't hear from you at 3:45, we will cancel discovery as not to incur cancellation charge. She should not have canceled discovery. So my thing here is, I didn't come out of the appointment because I was late for my appointment because of Courtney, because I had to respond to her before I leave because she wanted me to make a decision, right? Because the following day would have been the discovery, right? As soon as I got in my car, right, I left home, Courtney called me, and because when she got the email, right, I got in my car when she got the email from me to say no and all that. She was on the phone with me all the way to my appointment. I didn't tell her it was an appointment, and as long as the ride was, that's how long I had Courtney on the phone for. You understand? And then I told Courtney that I had to go. So then I told her I would get back to her. All right. She said, okay, try and get back to her before 4 o'clock. All right. I went to my appointment. Because I was late, I had to wait. I wasn't late badly, but still I wasn't there at the time they said, okay? However, I waited, so because of that now, I didn't get back in my vehicle until 3:50, 10 minutes to 4. And I said, okay, I'm going to call Courtney, right? And when I went on my phone. No, I said, let me check on my phone to see if she had sent an email. So when I went on my phone, via my email, looking on my email, right, I realized that she said that if you don't hear from me by 3:40, if I don't hear from her, if she didn't hear from me by 3:45, she was going to cancel. So when I read that, as soon as I read that, at 3:51, my phone rang, and that was Courtney. Yeah, and she told me she can. So when she asked if I received her email, and I said, well, I guess it's too late because it's now 3:51. I was sitting in my vehicle, right? And that's when now, it was canceled. But things were happening in the meantime that I didn't know. She just took matters in her hands, and then she was gonna tell me that there's no medical records on my what the doctors are saying. Some things that the doctors are saying, and then she's gonna say, "Are you saying the doctors are lying?" What lawyer? What? I don't understand. I guess maybe I watch too much movies. I guess with lawyer. I love lawyer shows. I guess maybe it's only the movies. She did say that to me. It's only the movies. I should have put that in. I should have put that in. This lawyer told me when I was telling her I love law. I love it. I don't want to be a lawyer. No. But, I like to investigate and solve cases, right? And did someone win or whatever. But here, this lawyer is actually telling me that, wow, that these doctors were not were whatever the doctor was saying. You understand? I know that when people commit murder, right, and these lawyers know that they committed the murder, they would lie for these people to get them off. Okay? Wow. Look at this now. They're not. Was it because I'm black? Was it? This is actually racism here at play. Okay? Please feel free to pause and read. Thank you. 20. Okay. Still brought forward. Much larger. Okay. I said, I do not have a wrongful dismissal documents and all the deceitful information. For the past year, Naimark lawyer informed that the examination for discovery was for wrongful dismissal without my involvement. Lawyer in combined both cases which were denied by mobility. She now wished to separate them a day before the discovery, right? And then I said deception, various reasons for delay, and I did outline them to you already. The Friday, the Sunday. The Friday said to organize a schedule for defense lawyers. Sunday, she said not fully prepared for wrongful dismissal case. Oh no, she did say that on Friday. That was Friday. Okay? And I did address that matter in my previous presentation. All right? Okay, feel free to review. Thank you. 319, I highly recommend. So secondment in the interim side. You see, this is proof that I actually was told by the lawyer that a mediation, and she said a mediation come before discovery. Feel free to review here and feel free to review here. He said, if we do not hear from you by 3:45, she would cancel. No, she should not have. Okay? You said you would review my email and reach out after 3 p.m. because we are running an errand. If we do not hear from you by 3:45, we will cancel discovery as to not incur a cancellation charge. I was at an appointment and I had to wait long until I was ready for there was a slot for me to go in for my examination. And this, honestly, by that time I was with Dr. Assad, and they actually during the examination they actually doing me wrong. So yeah, although I didn't want to tell this lawyer where I was still, because I was part of the system, flagged in the system, they were examining me and doing wrong by me. Okay? Anyway, 3:45, I was still I was still there. I didn't reach my vehicle until 3:50. Maybe I was almost out, but I didn't get in my vehicle until 3:50. All right? Feel free to review here. I was unaware about 3:50 p.m. I brought this one forward for a reason. I was unaware until 3:50 p.m. that my lawyer had threatened to cancel discovery at 3:45 p.m. This was taken from motion, eh? Yes, it's my case. Well, not really my case, but since this case is null and void, I can do whatever I need to do at this point in time, right? The lawyer contacted me at 3:51 p.m. and we were on the phone for a while. This email was sent from the defense on the same day at 3:58 p.m., right? So before she contacted me, right, I guess the defense already knew what was going to happen. 30 minutes after cancellation, while I was on the phone with the lawyer, right? Because this says here, from Amy R. Tibble, right? Monday, September 28, 2020 at 3:58 p.m., right? And it says here, this, let me backtrack. No, this is, I'm correct. The discovery for tomorrow will be adjourned and rescheduled. The parties are contemplating pre-discovery mediation as well. We'll keep you in the loop. And this was from Joanna. Whosoever this was to, I guess, because this is from Amy to Joanna. So, oh yes. So, Ixmorley Law speaking to Ixmorley Law. Subject external money, Bell Money Life. Okay, please feel free to review, all right? But they knew, all right? Amy Timble. Okay. Please feel free to review all this. 3:45, 3:50 I came out, and by 3:58, Amy Timble have all the information. Okay? Courtney Madison was copied in, and whosoever. Please feel free to review. Thank you. The breach of contract. This was actually extracted from their contract. No, yes, from their contract. September 29, 2020, breach of contract. The examination for discovery was cancelled without my consent. Naimark Law cancelled without my consent the examination for discovery, which was scheduled for September 29, 2020. A year prior, they had taken the examination for discovery from Benjamin Law, which was scheduled for August 16, 2019. It was cancelled after I was coerced to move to their firm. Naimark Law did nothing for my cases for over a year, never met with me once to discuss my cases, gave several reasons to speak with the defense lawyers, etc. Deception. All right, I have this information on the next slide for a better view. Okay, you can read my doodles here. Okay, obtained from contract signed with Naimark Law on July 26, 2019, breached. It says here, client to make all critical decisions. You see that? Did I get it wrong? Clients to make all critical decisions, firm to make non-critical decisions. Okay, during various critical times throughout the claims process, such as critical hearings, mediations, critical times, pre-trial conferences, critical times, without prejudice, settlement meetings, etc. The firm will explain the costs, the risks, and expenses of continuing with the claims, and the firm will provide their best assessment of the case based on the facts existing at the time. All right, the firm will not, however, make the decisions for the client in relation to resolution, and the client hereby acknowledges that it will make all critical decisions with respect to resolving their own claims. The firm shall, however, remain the decision maker when it comes to non-critical decisions, such as non-critical decision, requesting or agreeing to adjournments, non-critical, bringing or responding to motions, non-critical, selecting experts, non-critical. So you see, critical times, right, such as hearings and so forth, right? So if I did not respond to, say, cancel, should this lawyer cancelled and I did say no from the beginning, please feel free to review. Thank you. One of several breaches of contract, and as you can see, that's the contract there. Okay, and it's there. All right, please feel free to review. That's it. That's what I got. Please feel free to read if you wish. Okay, thank you. October 2020. Okay, Naimark Law insisted to have the examination for discovery cancelled September 29, 2020, so that they could have a mediation in October 2020. See emails dated September 28, 2020. I did not hear from the lawyer for the months of October 2020 and November 2020. Call received from the law office on November 30th, 2020. Motor vehicle accidents, right? Therefore, the person scheduled a meeting for December 11, 2020, since I was waiting to speak with the lawyer regarding a new date. I had received affidavit of documents in October 2020 to be reviewed with the lawyer. I had asked since I did not know the information they had. Okay, this is to deal with a motor vehicle accident, all right, which was already dealt with in the motor vehicle accident presentation. Okay. On September 29, 2020, Courtney Madison canceled the examination for discovery without my consent. It was the first time I heard of an affidavit. First time, eh? During our conversation. Imagine how they wanted me to go to a discovery and didn't know about affidavit. Can you imagine? During our conversation on September 28, 2020. Naimark Law, I guess that was a slip of the tongue. Naimark Law had no intention to have the examination for discovery since they were not prepared. I was not prepared by Naimark Law. I requested a review of the affidavit. I was unable to save copies of the contents of the affidavit since the files disappeared within 2 weeks. I did not know that the files would have disappeared, and as a matter of fact, I did not understand it at all. Right? I said here on Tuesday, October 6, 2019. Oh no, this was from Samantha, because Courtney told her to forward the affidavit to me, right? And I enlarged it for you. right? On Tuesday, October 6, 2020 at 10:21 a.m., Samantha Bray said, "Hi, Delane. I hope you are doing well. Courtney asked that I forward you a copy of the affidavit of documents we served on your behalf." Can you, as I said, I have nothing to do with any of my cases, eh? Okay, they serve the documents on my behalf, so you can review the documents, and also you advise that you may have some additional documents. Oh no, I would not be given those documents. No, I have sent you a copy of the link via OneDrive. The password to access the documents is Grant at the time. Yeah, if you have any problem accessing the document, let me know. Okay, and okay, I went in. I was able to go in. Okay, this is a document, and I was able to go in. On September 28, 2020, the lawyer stated there would be no mediation. Would be mediation. Say would be the mediation. Did not hear from lawyer. Okay. From Delane, from to Samantha, I said to Samantha, "Hi Samantha, please be advised that I do not understand the document that was opened with the Ontario Superior Court of Justice. Therefore, I have not placed my signature for consent." Yeah, the document was so confusing. It was so confusing. I know me. I try to understand things, but I just didn't understand, and I didn't know that it would have been taken away after a few days or so. It was taken away. The lawyer and I have never met in person to discuss my case, but I sent emails and spoke on phone briefly for her to get an understanding of the reasons I was suing the entities. This lawyer did her own thing. Yeah, because what I'm seeing is so confusing. Okay, then Samantha Bray on October 9th, right, responded, and she said, "Hi Delane, that is fine. A very brief explanation is that the affidavit of documents, this details and lists all relevant." So I'm telling you, the take out, take out, and I will prove it to you later on. All right, take out all relevant documents for clients' claims that are in a party's possession or control. It will have to be signed eventually, but it is not important at this time. Courtney will discuss the affidavit of documents with you further and expand on the explanation for the next examination for the discovery. Okay, before the review, thank you. Disappointed. I started to express my feelings, disappointment, in a letter on the same day, September 29, 2020, to Courtney Madison. In the month of October, I was still working on the letter, but decided not to waste my time, especially with my left hand. I have sent several emails to Naimark Law, which I have not received a response. Naimark Law firm was receptive. So here, said, decided not to waste my time in writing. So you can see I started lawyer Naimark Law. Deceptive, no emails or calls from lawyer in October 2020. Didn't hear from the lawyer. Feel free to pause and read if you can. Thank you. Okay. Month of October 2020. I had not heard from lawyer Courtney Madison or anyone else from Naimark Law. Email received at 2:19 p.m. on September 28, 2020. As you can see, she did say that I confirm on September 28th, right, 2020 at 2:19. I confirm I have recommended to you that we engage in settlement discussions and adjourn your discovery by 1 month. Okay. Two. Here again, month of October 2020. I have not heard from lawyer Courtney Madison or anyone else from Naimark Law. Email received at 3:19 p.m. on September 28, 2020. As you can see here, Monday, September 28, 2020 at 3:90 p.m. And what did Courtney said? Courtney Madison, she said again, "I would highly recommend that you accept my advice to put over the discovery 1 month and discuss on negotiating a settlement in the interim." That means that they are planning on doing a mediation. All right, 1 month. How could Naimark Law force me into mediation to negotiate settlement when I have never met with this lawyer once to discuss my cases? I don't even know the details of my cases and the amount being sued, especially since this law firm said that they take out and whatever. I do not know what they're planning. I do not know what they were going to present. We have to be on the same page. We weren't. It's obvious that we weren't, right? But 1 month of October started, and I didn't hear from this lawyer. As we go along, you'll realize that. Okay, feel free to review. Thank you.